Hi, welcome to Property Law 101. I'm Sara Bronin, and I created this series to help you understand the basics of property law. Today, we are talking about the fourth question, holding interest in property, and more specifically, holding shared interest. So there are three basic structures for shared estates. We've covered two of them in other videos: tenancies in common, joint tenancies, and tenancies by the entirety. Today, we focus on the joint tenancy. In the video about tenancies in common, I say that the way to distinguish the three structures for shared estates is to consider how a co-tenant may exit the relationship. So a joint tenancy is like a tenancy in common, except for what happens when a joint tenant dies. If that happens, the interest of a joint tenant is extinguished. The surviving joint tenant or tenants then get the interest. This is called the right of survivorship. The right of survivorship can be an attractive option for one major reason. If a joint tenant dies, the property does not have to go through the cumbersome probate process. So consider an example where the joint tenants had property in the proportions of 90%, 5%, and 5%. If the owner of the 90% died, the owners of the 5% and 5% would each then absorb 45%. We know a joint tenancy is created by considering the four unities with their acronym TTIP. Time, each interest has to be acquired at the same time. Title, each interest must be acquired by the same conveying instrument, not just by an act of law. Interest, each interest must be the same kind of estate, although the present ownership doesn't have to be the same. And possession, each party has to be able to possess all the property. Because these four unities are necessary before finding a joint tenancy, where there is an ambiguous document, a court will almost always presume a tenancy in common. So special language always has to be included to create a joint tenancy. So other than dying, there are other ways for a joint tenant to escape a joint tenancy. The primary way is to sever one of the four unities. If the joint tenant sells their interest to someone else, that person becomes a tenant in common without a right of survivorship against any of the remaining joint tenants. A joint tenant may also wish to keep an interest in property but no longer be a joint tenant. So in that case, the joint tenant can sell her interest to another property, a straw man, but then have the straw man convey the property back to her, converting her to a tenant in common. Courts take conflicting approaches as to whether a lease or a mortgage taken out by fewer than all of the joint tenants severs joint tenancy. Consider this example. O conveys the property to A and B for their joint lives with the remainder to the survivor. This looks a lot like joint tenancy. However, neither of the parties can unilaterally destroy the survivorship in this setup, so it is not, in fact, a joint tenancy. Note that a joint tenant can lease all of the jointly owned property to another without the other joint tenant's consent, because he has an undivided interest in the property. However, upon the death of the lessor joint tenant, the lease is void and the property goes to the surviving joint tenant in fee simple. So there's an example mixing leasehold interest, probably the kind of tenancy you're most familiar with joint tenancy, which refers to ownership interests and freehold estates. So I will leave it there. I'd love to hear from you, whether through Twitter or on my website, where you can sign up on to my mailing list, and I will see you next time.